So all that talking that you all couldn't hear was explaining the secretary review process that these two documents will go through. The policy process for the medical commission, they look at guidelines, interpretive statements, and policies. Guidelines can be reviewed and adopted by the commission directly. Interpretive statements and policies must go through what's called a secretary review process. So we're at the first step of this process at the interested parties meeting, where we will take comments, and then those comments will be considered and adopted or not at the policy committee meeting that happens in about a month. If the policy committee chooses to move these documents forward, it will go to the full commission, where they will choose not to adopt but recommend going through the secretary review process. At that point, we send these to the secretary's office, where the secretary's office comments, and they get comment from the other boards and commissions and other various interested parties that work within the department. And then the process essentially starts over, where those comments come to the policy committee again, and those are considered, accepted or not, and then they're moved forward to the full business meeting, where at that point they can adopt, and we will file these with the code revisor. And that process is, as I was saying, is not quick. So we're probably looking at a minimum at December before these could possibly be fully adopted and enacted. So that's the timeline that we're looking at with these. And so with that, we'll move on to the actual documents themselves. So the first one is the interpretive statement proposal for clarifying the eligibility for a license to practice medicine. This is basically laying out the position of the commission regarding existing statute. And so, as after review of existing statute with respect to the Medical Practice Act, the Uniform Disciplinary Act, the Administrative Procedures Act, it's clear that those are written in a way that assumes that the holder of a license is an actual human individual, and not a program or a model or anything like that. So that's the overview of that. So I'll accept any comments, questions, discussion at that point on this document, if anybody has any. Sorry, there's someone named M Toboggan. I'm trying to understand what you're talking about there. Do you have the ability to unmute and discuss?
Oh no, I agree with this. I just
Oh,
I guess I should save my comments for later on. I apologize. I was talking specifically about section G of the trainee one.
section G of the. Are you talking about the interpretive statement or the policy?
Interpretive statement.
Section G. Actually, I think you're talking about the policy, not the interpretive statement.
You're right, I'm mistaken. Apologies.
No worries. Okay, any comments on the interpretive statement? Okay.
Hey, Mike.
Jeb. Hey, Jeb.
Good morning, everyone. Jeb Shepard from the Washington State Medical Association. Just appreciate the Medical Commission's work in these areas. WISMA has a physician AI work group, and we've shared those documents with them, and we're still waiting to get their feedback. So should have more in terms of like a written comment we can follow up with more specific feedback. And then we'll be able to engage a bit more in depth at future meetings.
Sure.
I think generally we just want to make sure that some of the expectations in the document are practical for individual physicians.
Mm-hmm.
So we're trying to get some feedback there. And I think we would be interested in, if there are concerns, providing some language with for your consideration about
Sure.
like how to address concerns through these documents, because we do think they're important. So I want to work with y'all here. And then a couple things I can, I guess, more questions if now's an appropriate time to raise them about specific sections, or do you want to work through the document, Micah?
I mean, if no one's going to comment on this one, we can move to the policy, which is where I anticipated a lot of the comments would be. I see Eric Fish.
Hey, Micah, how are you? Just a question on that interpretation. That's the interpretation of current law. Does it preclude future licensure of sort of clinical AI, or is that just on the existing law as is?
Interpretive statements for the commission are existing law. And so as it is written, so I mean, you know, the scenario would be, can an AI, whatever, what have you, can it apply for the license? Can it respond to the questions and provide the needed documents? If the AI got a complaint, would it be able to respond in the mandated 21-day response period? Would it be able to comply with the civil rules of procedure in court? Our lawyers' assessments were definitively no.
But if a tool was able to do that, would there be a differing opinion or room for interpretation there?
I think there would need to be a law change, and that's based off the review of the Practice Act. It really is written with the assumption that it is a person doing that.
Okay. Thanks. That's clarifying.
No problem. Frank.
Hey, Mike, follow up from Eric's great questions. Along that note, some of that also talks about the practice of medicine as not just the licensure requirement, but the actual activity.
Mm-hmm.
You know, is there any intent or thought as to maybe future policies about delineating, just based on what you said, this seems to be aimed more about the administrative components of getting a license and what is required to go into that and to meet those obligations. But what about the activities, from just looking at it from a cease and desist kind of component? Should it, you know, be deemed that the activity is being engaged in since the licensure avenue is not available?
So that's where we get into, I'm not sure if it's a Washington unique scenario, but the Medical Commission does not have the authority to regulate unlicensed practice of medicine. That is exclusively the Secretary's realm. So if we were to get a complaint regarding that, we would send it to the Secretary. I'm not sure what they would do with it exactly, but that's kind of how we're approaching it. The policy itself, you know, there's some pretty clear exclusions, inclusions language up front about that, what it's really trying to take aim at with respect to the considerations. So that's, does that answer your question, Frank?
It does. It does. There's a lot of this is very helpful to informing FSMB's own discussions of the work group. So this really goes a long way. Thank you.
Sure. All right, and not seeing anything else, we'll move along to the policy. And I do want to come back to the individual who first raised her hand, M. Toboggan.
Yeah, no, I just, when I look at it from a trainee point of care for point G, when you see open evidence and when you see all these tools being used in educational scenarios, I just think that yes, we should balance clinical competency, but at the same time, we have to acknowledge that in the future, this will be a part of clinical care, and trainees shouldn't be behind while using it. There's reasonable points to be made on both sides of this issue.
Yeah, and just to address that, that's why, and I guess, and Marlon is from HSQA, and so he works on policy stuff on that side, and this, because of the content and the subject of this particular policy, it's both policy and guideline. And so in the, you know, when we're looking at the document itself, you know, you're looking at this bit where the first part is the actual policy itself, and the rest is really just discussion and background. Then you hit the scope, which again is saying what's in and what's out. And then the rest, when we start in section 3, that's the discussion of what's the key points of the policy. But again, this is more in guidance to help clarify what what the intent is. We chose to go this way so we wouldn't have a policy document and then a guidance document about the same thing. We wanted it to be sort of a one-stop shop where it made it a lot easier for folks to deal with that. I agree. There's certainly points on both sides with respect to using those tools, and I think that that there's certainly considerations to be made. Part of and I'll give WISMA a shout out here. Part of this was informed by a symposium that WISMA put on in, I think it was January of a year or so ago, where we actually had clinicians who were responsible for training those trainees expressed some, I would say, some pretty legitimate concerns is using AI tools in their training without being able to functionally accomplish what they needed to do in their PGT. So as a result, they either restricted or did not allow them to use it until they could do it the old-fashioned way, so to speak. Jeb?
Yeah,
That's
Micah
one.
and everyone, I apologize for injecting some confusion into this meeting. I was referring in my previous remarks to the policy document, not the interpretive statement. So we have both of these in front of our work group. I think the one where we would have more feedback is this policy document, whether or not some of these are practical for individual physicians, especially ones that are, employed by large health systems or medical groups that don't select or procure these tools, may not know who the vendor is, understand the need to understand the tools that they're applying to patient care, certainly. So we'll get feedback there. And again, hope to work with you all on the language. And then not an attorney, but did want to flag something at the bottom of the document. So it's the last page, last line, I believe. Failure to adhere to these expectations may constitute unprofessional conduct under the UDA and may subject a licensee to disciplinary action by the commission. Just want to clarify that this policy document is interpreting existing obligations under that RCW and not creating new independent duties. And then if you could help square like that language with like some of the sections, and at least one is it says best practice guidelines. And so that might be confusing to some folks that are reading this. So I just wanted to call that out.
Sure. Yeah, I think we can probably relocate that. And you're right. The policy is not intended to create new requirements outside of statute. It's really saying the policy of the commission as it applies the law and the rules is contained here. But yeah, we can certainly clarify that. And with respect to some feedback to your work group, I think, when you're talking about the vendors and that sort of thing, one issue that we're seeing consistently is the disclosure of the failure modes of certain tools. And so that seems to be, whether, and I think it's depending on who you talk to, whether it's the vendor or whatever. There's been some approaches that failure modes and disclosure of such is proprietary and is proprietary information. So therefore they don't want, we're coming along at the commission staff level as to view that as a pretty big patient safety risk. To not know, okay, well, this tool that looks at CT scans, it's very good at spotting, say, lung cancer, but it's got a 50% failure rate of spotting thyroid cancer, that sort of thing. And that's probably not even a clinically accurate example, but that's just the one off the top of my head. So that's one of the things that we're really, really looking at is, how does the clinician know that there's a area of the tool that's weaker than some others, and if there's a way to accurately address that or describe it, or at least warn the clinician to be mindful or ask key questions, then we're happy to try and do that.
Thanks, Micah.
Not a problem. Any other comments or questions? Dr. Fino, I see you're on, and is there anything that you wanted to add or comment on?
Thank you, Micah. No, I'm just actually reviewing these for the first time. I apologize. And nothing is sticking out, but thank you for the airtime.
Not a problem. Dr. Fino is one of our medical consultants for those that know, and so she works with our compliance program, but also consults with us quite a bit on clinical issues. Eric.
Micah, just a question around the use of meaningfully review. Is there guidance from the board on what meaningful review is going to be, or is that going to be developed alongside this policy? One of the things that I've talked to different industry groups is that they all say meaningful review, but no one has given parameters for what that means, what sort of evidence should be incorporated into the record, what a board would want to see for those physicians who are using it.
Could you help me zero in on what you're talking about? Like a section.
Let me pull it up. There, you go. If I think it's you go up in the first section. I'm sorry, or the first document that you talk about. Sort of the human in the loop. That section.
Okay, for human in the loop.
Yeah, the second line of the second paragraph, it requires that the licensee meaningfully review. Just one of the things that I've had to talk to clients and some hospital groups and other industry groups about has been what meaningful review means in the context of a medical board's review of activities as it goes to like the standard of care. So I don't know if that's something that the group has thought about or could improve this document by saying meaningfully. Evidence of meaningful review includes, but not limited to, certain types of things that are elsewhere in the document.
Sure. I guess and this is calling on your experience with your past employment. So just
Should we go ahead and disclose I was at the FSMB before?
Yeah. Just so everyone knows, I've worked with Eric for years with FSMB, and he is now gone to Hooper Lundy. Is that where you're at?
Hooper Lundy Bookman, yeah.
Yeah, and so, but he just still does work there. So I guess in hearing your comment there, my question is: do other boards have guidance with respect to medical devices or anything else about meaningful review and how and what that constitutes?
I don't know if it's explicit. I think it's something that would come up if there's a complaint or concerns about how something is factored into a decision. The physician would have to provide evidence, but I think that would all go through the disciplinary process, be factual, sort of fact gathering by the board and the investigators. But as you look at this policy, I think one of the things that folks are really looking for, at least the questions I get, ties to, did we do enough? Because they're using these tools, but are we meeting this? And it's also being built into hospital compliance of what a physician needs to review before they sign off on it.
Okay.
So it's sort of a downstream effect of if you've got a system in place or a tool that's being used by a facility, the physician wants to know what their duties are and what they're obligated to maintain records wise, what they need to put in, how they should frame that. So they said, yes, we've meaningfully reviewed. It's sort of an ambiguous term, one that the lawyers love because we can debate it all day. But I think there is some interest by the industry in fleshing that out, at least from a board's perspective.
And I guess I'll ask you and the group, would the preference be to come up with some sort of guidance definition about meaningful review or interrogating, the AI generated output, or would the preference be to delete meaningful review and interrogate and just simply say that it requires that the licensee exercise independent judgment? Because there's two concepts to my mind here. There's number one, knowing what you're using and not being over reliant on it. But the other piece is making sure that our licensees are exercising their independent judgment and aren't being told, you will use this because I said so. And while there is discussion about would the use of AI in the future become, or not using AI become a violation of the standard of care in the future, we're not there yet. And so the question really is, how do we maintain that independence for the licensees and give them some cover, so to speak, but also how to make sure to give them the guidance that they need to know, okay, this is how we would use this, and if we need to develop standards on that, we can do that.
Yeah, I think you could maybe reword that second paragraph to lead with that human in the loop is not a merely passive concept. And then say physicians, because later in the policy you have it talked about, but you could say physicians must always exercise independent judgment about the output. Exercise of independent judgment includes meaningful review, or would include meaningful review as evidenced by such things as. It's a little wordy, but I think that kind of goes to the concept you're trying to get to with that,
Okay.
with that line, and still give some flexibility on what that could be, but also give some guidance on what you would like to see from a board,
Okay.
board's perspective.
All right. Thank you. And I'm assuming that M. Toboggan is Dr. Toboggan, so I'm just going to go with that. What would meaningful review on a future Midjourney scanner look like? Could you clarify your comment there?
No, I'm just a trainee, but you're very kind, thank you. But like for the Midjourney new scanner, like what would meaningful review look like if it has if it has general FDA exemptions for class 2, but if it picks up something incidental, like would the physician still be liable for that? What would meaningful review look like in that scenario?
Okay. All right. Thank you for the scenario. Okay. Any other comments or discussion? Seeing none, I would thank you all for attending. This is probably our best attended and most lively interested parties meeting we've had since we've created these. So I appreciate it. As always, if there are comments, you can submit them to medical.policy@wmc.wa.gov. And our website has the full documents in the meeting packet. The next step is again will be the policy committee meeting. And let me just jump over there to make sure I know what date that is. Sorry, that's July 23rd from 4 to 5 p.m. And so I'll drop the link in the chat. You can feel free to go and register for that. We look forward to everyone participating. And with that, we will call the meeting to a close. Thank you very much.